Hello everyone, welcome to Innovation. I'm Shantanu and I bring to you the sixth part of our business awareness series. And in this video, we are going to discuss major labor laws of India and also the acts governing them. So, friends, there are various acts and various laws which it is not possible to cover all of them, but we will discuss the relevant ones today, which as a manager and as a future employee, you must know. So, friends, do watch the video till the end, and also there will be one act which I'll give you as an assignment to read about. Okay, so let's start the session. So the first act that we'll discuss is the Trade Unions Act of 1926. So friends, आपको एक्ट का नाम पता होना चाहिए, उसके बारे में डिटेल्स और बेसिक डिटेल्स और द ईयर ऑफ द एक्ट. सो ये चीज़ें आपको पता होना चाहिए. So what is this Trade Unions Act? So it's about the formation of trade unions and their registration rights and responsibilities. So trade union basically क्या होता है दोस्तों? It is a association of various employees or workers who come together for protection of their own interests and rights. And this acts govern their registration rights and responsibilities. So why it is done? Because एक अकेला एम्प्लॉई है या एक अकेला वर्कर है, ही इज़ नॉट दैट मच केपेबल टू पुट हिज questions or his demands in front of the employer. So what they do is they use the concept of collective bargaining. That is, when a lot of people or whole of the employees come together as a bunch, as a team or as a union, the employers have to listen to them, and there is a condition that the demands that are in these demands should also be genuine. It is a must, and they must be in the interest of all the workers. It is not so that only one person should be benefited, the whole group should be benefited. So that's why they form trade unions. And another important thing that you should notice, a trade union with minimum of 7 members. So if you want to form a union in a company, you need to have at least 7 members to it, and only those can with 7 members can apply for registration. Such a trade union shall mandatorily follow the rules of the act, and they must pay a prescribed fees also for the registration. And so the unions which do not get registered are not governed under this provision of Trade Unions Act of 1926. Next is the Industrial Disputes Act of 1947. सो देखते हैं इस एक्ट के बारे में. सो ये एक्ट क्या गवर्न करता है दोस्तों? इट डील्स विद द इश्यूज ऑफ डिस्प्यूट्स लाइक क्लोजर, यानी कि प्लांट कम्प्लीटली बंद हो जाना. लॉकआउट, इट मीन्स दैट if there is any dispute, all the workers are kept out of the company. Lockout, you can understand from the word only, locking the doors of the company and with the workers outside, not letting the workers inside the premises. Strike, you know that all the workers do not come to work because of some demands. Retrenchment is cutting the pays, and layoffs, as you all know, ले ऑफ मीन्स नौकरी से निकाल देना. सो ऐसे कुछ इश्यूज होते हैं, तो उसको कौन गवर्न करता है? इट इज़ गवर्नड अंडर द इंडस्ट्रियल डिस्प्यूट एक्ट ऑफ 1947. देयर वेरियस एलैबोरेट मैकेनिज्म फॉर द डिस्प्यूट रेजोल्यूशन. सो सबसे पहला स्टेप होता है किसी भी डिस्प्यूट को ख़त्म करने का. इट इज़ कॉल्ड कंसीलिएशन. इट मीन्स डिस्कशंस के थ्रू उस डिस्प्यूट को ख़त्म करना. नेक्स्ट स्टेज होती है आर्बिट्रेशन. So, as per this act, a neutral third party hears the parties in disputes. So, some third party which is neutral will hear both employers and trade unions leaders, and they will come to a conclusion and decide which is binding on both the parties. So, they'll find a middle path for both the parties. And even if then the dispute is not resolved, फिर क्या होता है? Then the dispute may be referred to some industrial tribunals, labor courts, or even to the national tribunals, where the resolution will happen further. Next, so strikes and lockout are regulated by the act. So ऐसा नहीं है कि laborers जब चाहे तब strike कर सकते हैं without any genuine reason. And the act lays down certain circumstances under which they are prohibited. Even lockouts and strikes are prohibited in certain cases. And the acts also provide for compensation to the workmen in case of layoffs or retrenchment or transfer closure of the undertaking. अगर कंपनी आप डायरेक्टली बंद नहीं कर सकते हो, you need to give some payment to the workers if such a case happen that you are directly laying them off or doing a retrenchment. So this act has certain provisions regarding it. Moving forward to the next act. Next is the Minimum Wages Act of 1948. So the main aim of this act is to ensure that all the laborers or the employees get fair wages and has access to basic physical necessities, proper health and comfort at the workplace. Moving forward, so the government is empowered under this act to fix minimum wages and revise them regularly. So government can even change the minimum wages of the employees at regular interval of times. And friends, the minimum wages are fixed according to three important criteria. It can be time rate, like the number of hours you are going to work, or piece rate, that is number of pieces of final product that you are going to produce, and overtime rate. So it governs if a person works more than the allocated amount of time, then he is entitled for overtime payment. Next, there are penalties under this act too for non-compliance for the provisions by the employer. अगर employer इन सब rules को follow नहीं करता है, minimum wages नहीं देता है, so there are strict provisions under the law which will punish him monetarily. Okay, so moving forward, the next act that we'll discuss is the Employees State Insurance Act of 1948. So friends, again, as the name suggests, it's all about insurance. Let's see how. So this act basically focuses on the safety of the employees by providing help in case of sickness, death in the work due to injury, due to work field injury, maternity, etc. So in such cases, the employee is entitled to get help by the employer. So let's see how. So medical benefits is extended even to the family members of the employees, and the funeral benefit is paid to the eldest surviving member of the family or in his absence. So अगर death हो जाती है workplace पे, so that funeral benefit is also paid to the eldest person in the family remaining. And friends, another important thing is that both the employers and employees have to contribute some amount toward this insurance fund, which is named as Employees State Insurance Fund. And this fund is held by which organization? It is Employees State Insurance Corporation for Administration. This organization was created under this act, which holds this fund. And last thing, the provisions of this act is applicable to employees who are taking a monthly salary of rupees 21,000 per month or below it. So it is applicable for them only. Okay, let's move forward to the next act. Next act that we'll see is the Factories Act of 1948. So friends, this act also is somewhat related to the safety of the employees. Let's see how. So this act will helps to regulate the working conditions of the workers employed in factories and lay down provisions to ensure adequate safety measures. As I told you, there should be adequate safety measures to implement in the factories for the welfare of the work and also to reduce injuries as much as possible. And the act imposes upon the owner of the or the occupier. So friends, occupier का meaning ही होता है owner of the company, who controls the company of such factories, certain obligations. They have certain obligations to make sure that employment is in conditions conducive to the health and safety. So there are various production companies, manufacturing companies, which need to strictly adhere to safe practices and healthy practices at their workplace. Okay, like they have to provide certain protective equipments to the employees so that they can work in a safe environment. So the act is applicable to any factory whereon 10 और more workers are working. So कोई भी फैक्ट्री है अगर 10 members हैं, then you are under this Factories Act of 1948. Two other important things that this act provides is that working hours of the adults, and the working hours should not be more than 48 hours in a week. And the another important thing is that there should be a weekly holiday provided to each and every employee. So the employer must consider these two as strict provisions of this act. Moving forward, next and another important act is the Maternity Benefit Act of 1961. So friends, this act is all about protecting the interest of women by governing the employment of women in mines, factories and other various establishments. And this act was recently amendment in 2017 by Modi government, and we will see the major amendments here because they are more relevant for us today. So the first highlight is that the paid maternity benefit has been increased from 12 weeks to 26 weeks. Earlier, as per 1961 Act, the maternity benefits was around 12 weeks, and now it has been increased to up to 26 weeks. So this is around half of the year, and up till two surviving children. So up till two children, the maternity benefit will be availed up till 26 weeks. And if you have more than two children, then it will, for that children it will be 12 weeks for the third from the third child onward. Okay. And maternity leave for child beyond the first two child will come to be 12 weeks, as I told you. Also, if a mother adopts a child, then maternity benefit of 12 week will still be available up to for the children's below 3 months of age. नेक्स्ट इज अनदर इम्पॉर्टेंट थिंग इज दैट कोई भी अगर कंपनी है, कोई भी स्टैब्लिशमेंट है एंड इट हैज़ मोर देन 50 एम्प्लॉयज़, it needs to provide a creche facilities for the working mothers, and such mothers will be permitted to make 4 visits during working hours to look after her baby and also to feed the child in the creche. So this is another major provision of this act. Moving forward, the next act that we'll study is the Payment of Gratuity Act of 1972. So let's see what actually gratuity means. So gratuity is the sum of amount paid to an employee by the employer after the completion of his employment. So we can say that after retirement, the sum of amount that a employee gets is gratuity. And the important provision for the act is that an employee engaged in various establishments, for example, mines, factories, oil field, railways, etc., where more than 10 or more than 10 persons are employed in the preceding 12 months, the act will govern such companies. So these companies have to follow, and these companies come under this act only. Moving forward, so earlier what happened was that gratuity up to 10 lakh was exempt from the tax, but now this exemption has been the bar has been increased to up to 20 lakhs for employees covered by the Payment of Gratuity Act through an amendment in 2018. So under Modi government, the tax exempted gratuity has been increased up to 20 lakhs. So the next is the Equal Remuneration Act of 1976. So friends, as the name suggests, equal remuneration, that is equal payment to everyone, including men and women. So let's see how what are the details. So the principle of equal pay for equal work for men and women is embodied in Article 39 of the Constitution. So our Constitution, even our Constitution has this provision that for equal work, men and women must be paid equally. So this to give effect to this constitutional provision, our Parliament of India enacted the Equal Remuneration Act in 1976. So for fulfilling the needs of this provision, this act was made. And as per this act, as you can understand, equal remuneration should be paid to men and women worker for same work or work of similar nature without any discrimination. So friends, on the basis of sex, you cannot discriminate the wages, and for the same amount of work or same nature of work, both men and women must get equal pay. That's a very important and very relevant act in today's world. Next, this act also prevent discrimination against women employees while making recruitment. अगर आप रिक्रूट भी कर रहे हो सेम काइंड ऑफ वर्क नेचर के लिए, सो यू कैन नॉट डिस्क्रिमिनेट on the basis of sex of the new employee. And the last thing, any non-compliance with this will be an offense and shall be liable to proceed against the and punished accordingly. So there will be criminal proceedings against the employer, and he'll be punished under this act if he is non-compliant and discriminates among men and women for the same kind of the job. And the last one is Child and Adolescent Labor Prohibition and Regulation Act of 1986. And friends, this is your assignment act. Please do read about it and make short notes. And if you want to share it with others, please comment in the comment section and tell everyone what you have understood of it. Okay, so we have come to an end to this session. I hope you guys are making notes of all the acts and the details and the year of their enactment. So thanks a lot for watching. If you have liked the video, please give it a thumbs up, share it with your friends, and subscribe to Novation for more awesome content. I wish you all the very best. Bye bye, and see you next time.